Good afternoon, everyone. My name is Marta Minetti, and I'm a third-year PhD candidate at Queen Mary University. My project looks at the contemporary phenomenon of human smuggling, critically examine the application of the anti-smuggling provisions to counter the rescue activities carried out by the NGOs in the Mediterranean area, and examines the wider implication that the criminalization of human mobility has for the foundation of criminal law and the rule of law at large. Today, I'd like to present to you an extract of my PhD thesis and focus on the expansion of the populistic reach in the persecutorial field by examining and exposing the variety of legal tools applied by the Italian prosecutors to counter the activities and criminalize the NGOs uh, in the Mediterranean area. I'd like to start my presentation by providing you with a little bit of data and background information on the origin of the relevant legal frameworks. More specifically, the tendency of the Italian authorities to criminalize NGOs started in 2017 with the famous allegation that some NGOs were cooperating with the smugglers in Libya. Although the Italian Senate dismissed the allegations, the trend to criminalize humanitarian actors took off, and since then the Italian authorities have started taking measures, including seizing ships and launching criminal as well as administrative investigation to address actions by NGO deployed vessels considered to exceed their rescue at sea activities. And today, the legal proceedings active against NGOs are in Italy are 18, um, not counting the recent developments in the cases of Sea-Watch. Sorry, Sea-Watch 4, which seizure has been suspended last week on March 3rd, and Mare Jonio, which is under investigation for allegedly being paid to rescue migrants. In terms of legal and political development that has contributed to leading to this tendency. In the past 20 years, we have witnessed an increase in the focus devoted by the international, national, and European policymakers to the issue of irregular migration, with a tendency to rely on criminal law tools to counter this phenomenon. Parallelly, the last decade has been characterized by the rise of populist movements across the Western world, and particularly in Europe. Among the provision aimed at tackling the alleged security threats constituted by the migrants, by the foreigners, as put in the populistic discourse, the facilitators package has been and still is among the protagonists of the criminalizing approach adopted by the European legislator due to its aim to tackle irregular migration by strengthening the penal framework on the facilitation of unauthorized entry. These obstinacy to counter the activities carried out by the NGOs active particularly in the Mediterranean Sea is not aimed at punishing or rehabilitating a specific perpetrator, but rather at preventing the occurrence of the irregular arrival of migrants within European borders and to deter irregular migration, its facilitation, regardless of whether the crime has been committed for the purpose of obtaining profit or to provide assistance. Following this trend, the Italian legislator in particular has shown a tendency towards a compulsive criminal legislation intended as the production of new norms designed to give law enforcement agencies powers to respond to alleged crisis situation but lacking normative foundation. Such an indiscriminate increase of the number of criminal laws carrying only symbolic relevance is a consequence of the necessity to respond to and to soothe the emotional need of the electorate. It is on this analysis that I base my claim that the current criminalization of migration, which in Italy has taken the shape at first of the criminalization of the migrant and then of the actors facilitating the migration, constitutes an expression of the expansion of the populistic trend in the criminal law domain. There we go. The anti-smuggling law is codified in Article 12 of the Consolidated Text on Migration, which is an incredibly wordy provision, and is aimed at including in its criminalizing scope the largest number of situations involving the facilitation of illegal crossing of borders. The definition of smuggling in the Italian framework resembles very closely the EU definition of the crime, And as you can see from the slide, the purpose element of financial gain is left out from the constitutive element of the simple form of the crime, and is defined again in the as an aggravating circumstance. So we have aggravated smuggling if the crime is committed with the aim to recruit person to destined to prostitution or exploitation, or it is committed for the to obtain profit. So the profit element is included as an aggravating circumstances rather than a constitutive element of the crime. Furthermore, the contents of letter A, the aim of recruitment into sexual labor exploitation, result in an overlap between the aggravated form of smuggling and the anti-trafficking law codified in Article 601 of the Criminal Code, which mirrors the UN trafficking definition. We are going to get into more details on the expansion of the prosecutorial level of the prosecutorial powers resulting from this overlap. But before, I'd like to devote some attention to the transnational organized crime framework and how it results in the applicability of the anti-mafia national legal framework to contrast migration-related crimes. In fact, the fact that Article 12 should allegedly transpose not only the contents of the facilitators package, but also those of the smuggling protocol ratified in the context of the fight against transnational organized crime, enables the Italian authorities to rely on the anti-mafia legislation, a provision that is at the center of numerous debates due to its repressive and preventive nature. It is in this context that the debates around the populistic entanglement of immigration law, criminal law, and administrative law have been conducted. The preventive function adopted by criminal law, fed by the need for reassurance of security from future crimes, results in an increased relevance and powers of law enforcement agencies in charge of combating a depersonalized criminal phenomenon that in this case is mafia and irregular migration, rather than a specific perpetrator. So to sum up the effects of the applicability of the anti-mafia legal framework in the prosecutorial field, it results in the expansion of the investigative and prosecutorial powers, in an extension of the jurisdictional reach outside the national borders and territorial waters, and in the applicability of personal and financial preventive measures, including seizure and confiscation. So as previously stated, the normative overlap between the aggravated form of smuggling and the trafficking provision in the national criminal law framework has a number of consequences in terms of expansion of prosecutorial powers. More specifically, trafficking situation can easily be miscategorized as smuggling. This means that smuggling and humanitarian assistance and trafficking fall all under the same provision, Article 12, and humanitarian actors can actually incur in the same sanction as traffickers. Here's some jurisprudential evidence in the slide, some jurisprudential evidence on the ways in which trafficking situations have been codified to fit them in the smuggling definition. A further legal tool, legal framework adopted by the Italian prosecutors to counter the activities carried out by the NGOs derives from the National Navigation Code. The most emblematic case in this case is the Rackete the case of Carola Rackete, the captain of Sea-Watch 3. Specifically, the captain faced allegation of resistance and violence against a warship and resistance to public authority. This case has been particularly relevant for the Italian jurisprudential evolution because for the first time since this trend appeared in 2017, the High Court of Cassation released the judgment on the topic of the juxtaposition between the duty to rescue and the authority. More specifically, after the judge of Agrigento refused to confirm the arrest, the prosecutor appealed to the Court of Cassation and the Court of Cassation dismissed the appeal. The relevance of the judgment is given by the establishment of a series of legal principles, the most relevant of which is undoubtedly the one establishing the prevalence of the duty to rescue over the one to defend national borders. So the Rackete judgment gives some signs of hope. However, these signs of hope after the outbreak of COVID-19, shortly after the release of the Racchette judgment, brought back in fashion the adoption of further legal tools applicable in emergency situations. In fact, in last April 2020, the Italian Minister of Infrastructure and Transport has established that for the entire period of the health emergency resulting from the spread of COVID-19, Italian ports will lack the necessary requirements to be classified as a place of safety. The measure was justified juridically with the declaration of the state of emergency and politically with the need to protect public health by avoiding new outbreaks from potentially infected migrants. However, the differentiation operated by the legislator to close the national ports only to foreign boats or embarkation carrying rescued migrants, while permitting Italian boats to reach the national ports, shows a willingness to instrumentalize the emergency framework to counter irregular arrivals in the territory, and it's in direct contradiction with the Racchette judgment and its principles. The reliance on the legal framework protecting public health and safety to hold the NGOs accountable, however, was in place even before the outbreak of COVID-19. And the most important case in this case is the Aquarius one. In this case, the vessel of Aquarius was used by Médecins Sans Frontières and SOS Méditerranée, was seized following an inquiry started by the prosecutor of Catania, who accused the crew of illicit disposal of the waste produced by the rescue ships. Despite the fact that the local tribunal did not confirm the allegation and release the vessels, the Aquarius remained inactive for more than 4 months. The presentation is aimed to provide an overview of the variety of legal tools and frameworks employed by the Italian prosecutors to counter the activities of humanitarian actors and to create an hostile environment for the rescuers and rescued. For this reason, and because the Italian management of irregular migration has been at the center of public attention for the application of criminal law devices to prosecute humanitarian actors, the Italian case constitutes a perfect laboratory on which to draw reflections on causes and consequences of overcriminalization, specifically in the field of migration, and upon the future of the criminal law domain. Thank you very much for your attention. I really look forward to your questions.